Go, Dan.
Yeah, let's kick it off.
Everyone's in the room, so we'll make a start. Nurinj Womaninji, Netumakta Paul Payton, Naju Gunai, Naju Nagaraga Monero, Naju Tunganai Waru Work. My name's Paul Payton, the CEO of Federation of Victorian Traditional Owner Corporations, and I'd like to welcome you all today to the fifth of the series of 6 lunchtime webinars that have been developed from the insights and questions posed during the traditional owner engagement meetings about treaty way back in 2019. So a few years ago now, but we've certainly learned a lot along our way. So that's also contributed to today's paper and presentation. As a statewide body that convenes and advocates for the rights and interests of traditional owners, this series of webinars aligns most strongly with, not uniquely, but to one of our 4 pillars of knowledge sharing, and that pillar is focused on enabling more connected, informed, and innovative traditional owner corporations and communities throughout the promotion of resources and events and information sharing opportunities, so we can learn from each other and learn from those experiences. So today's presentation, it's about framework for traditional owner treaties and the lessons learned from the Settlement Act, which is the 5th paper. It's now available on our website that you can download. If you haven't already done that, go to our website and download the full paper and have a read of that. And there's one final paper that's currently being developed, and I'll aim to summarise and contextualise all of those papers together. So I'm looking forward to getting that and seeing that summary of everything coming together. But specifically today's presentation, its purpose is around examining the 10-year history of the Victorian Traditional Owner Settlement Act, with it being close yet imperfect equivalent to a local treaty framework. And to assess what useful lessons can be drawn to inform Treaty Act negotiations. So as indicated before, it's now more than 10 years since the establishment of the Settlement Act. So what are the direct experiences of that reform? How does having immediate history from which to draw upon inform the development of a local treaty regime? So there's probably many more questions, but it's really, how do we look back and use that to look forward? I'm certain it can provide a view to the practical implementation and navigating some of those hurdles and problems that the reform envisaged by the Treaty Act will inevitably face as well. So I think there's a lot to be learned from that. So I think we'll get into it so that we can get through the presentation. So without further ado, I'll hand over to Dan Kelly, who's our General Counsel at Federation, and he'll deliver the presentation today and answer any questions that you have. Hopefully you get a lot out of it, and just a reminder that the question and answer, don't use the chat function, use the Q&A function to answer your questions, and we'll get to those at the end. So thank you, and over to you, Dan.
Thanks very much for that introduction, Paul. And as Paul said, so the topic today is a framework for traditional owner treaties, lessons from the Settlement Act. Just a brief word on the discussion papers, this series of papers we've put together. Their purpose isn't to represent, and we don't suggest that they represent the views of traditional owners or even of the Federation or our members. Really, these are just discussion pieces. One thing we've tried to do throughout the papers is adopt a process of trying to move from rhetoric to practice. So we're taking a whole lot of these concepts and aspirations of traditional owners over a long period of time, things like sovereignty and self-determination, and trying to examine how they might be put into place in a practical way. So we've done 6 papers in total. This is the 5th. As Paul said, there will be a final paper to come, which will essentially just sort of provide a sort of overview of the rest and hopefully provide some sort of proposal for a comprehensive treaty model. I'll talk a little bit to the content of those papers just in this slide, because it is important, I think, just to have a bit of an understanding of the proposed treaty model which we're working against, and which the papers are structured around. So the kind of cornerstone we see to this model is an Aboriginal, a democratically elected Aboriginal body, which we call the Treaty Representative Body, or the TRB for the purposes of these papers. That could be a body like the Assembly, or some sort of evolution of the Assembly. And we see that body entering into a statewide treaty with the state government of Victoria. And we look at that concept in detail in paper 1. We also see within this statewide treaty that it would establish the TRB as a sovereign body. So that might mean it has legislative powers, or a voice to Parliament, or reserved seats in the Victorian Parliament, something of that nature. And we delve into that in paper 2. We also think the statewide treaty should recognise Aboriginal rights, and by that we really mean it should seek to entrench and implement UN DRIP. We look at that in paper 3. And paper 4 deals with Aboriginal control of Aboriginal affairs. So this was looking sort of in depth at how legislative powers might be operated by the TRB. And I'm sure, apologies, I just got an update and I'm sharing the wrong thing. Let me get out of this for a moment. Technical difficulty here. Is that better, Paul? Are you seeing the right slide? Overview of...
Just coming through now, overview of proposed model.
Yeah, apologies for that. So Aboriginal control of Aboriginal affairs, we were looking at how legislative powers might be exercised by a traditional owner parliament. And today we're looking at the framework for local treaties. So all the previous papers have really focused on those sort of statewide issues. This paper is really starting to look at the local level and what agreements might look like between individual traditional owner groups in the state. But we would see this framework itself perhaps being embedded within the statewide treaty. And so we'll get into that paper today. Now just sort of commencing the review of the paper itself. You know, as we know, in 2018, Victoria became the first state to enact treaty legislation, to allow the negotiation of treaties between its Aboriginal citizens and traditional owners in the state. But this wasn't the first time Victoria had sought to lead the nation in innovative responses to colonial dispossession. In fact, almost exactly a decade earlier, in December 2008, a joint TO and government steering committee released a report that laid the groundwork for what would become the Traditional Owner Settlement Act 2010. And the Settlement Act was really presented as a reimagining of native title for Victoria, and it was a break with some of the more restrictive constraints of the native title legislation. It also aims to provide a speedy and efficient resolution of claims. So we think the Settlement Act is a useful starting point if you're thinking about a local treaty framework for Victoria. Firstly, it mirrors in many ways some of the treaty processes you see around the world, particularly British Columbia. The Settlement Act bears a lot of resemblance to the British Columbian process in terms of authorising requirements, and even many of the rights that treaty citizens receive in British Columbia are also available under the Settlement Act processes. But those comparisons really only go so far, because there is a conceptual difference in the way Treaty and Settlement Act approach traditional owners. Particularly, the Settlement Act and the Native Title Act conceive of traditional owners really as rights holders in land, and not as a political community or any type of sovereign entity. So there is this inherent conceptual difference, I think, between what treaty is attempting to do and what the Settlement Act is trying to do. But nevertheless, the Settlement Act aims to be a sort of statewide comprehensive system, and it gives us this 10-year, very local history where we see the same parties that are likely to be engaged in local treaty negotiations. We have this 10-year history of them engaging in detailed, complex negotiations around contested rights. And for that reason, it's a useful starting point. So just an overview of the paper. We'll start with a look at the limitations of the NTA and how the Settlement Act developed out of that. We'll then look at the content of a standard Settlement Act agreement. We'll try and evaluate the Settlement Act and identify some of its flaws that we think should probably be addressed through a local treaty framework. And then lastly, we'll put some concrete proposals around that. So just looking at the limitations of the NTA and the development of the Settlement Act, as we all know, the Native Title Act has its origin in the Mabo decision in 1992, when the High Court found that in some circumstances, in appropriate circumstances, traditional rights could be recognised as legally enforceable in Australian law. But it was clear from the outset that native title would favour traditional owners not subject to extensive colonisation. That is, traditional owners that were living in highly settled or developed areas would likely receive less favourable treatment than those in more remote areas. And the reason for this is that native title rights are inherently vulnerable to extinguishment. What do we mean when we say extinguishment? Essentially, it means that the rights are eradicated, the rights are extinguished, and they are gone. So there's two scenarios historically where native title rights would be extinguished. I'm having more problems here. There we go. The first thing that would likely will lead to extinguishment is if the Crown grants rights to land which are inconsistent with the continued exercise of native title rights. Now, the prime example of that is the grant of freehold land to settlers. So when the Crown comes in and grants rights to whitefellas, that will extinguish native title rights. The second scenario is where the traditional connection to the land is lost, where the traditional law and custom from which the rights arise is no longer able to be practiced. The rights can be extinguished and they can't be revived. The things that can lead to that type of outcome, are forced removal from country. As we know, that was exceedingly common in Victoria. And it happened by violence or the threat of violence. Nevertheless, the Native Title Act doesn't take that into account, and it can lead to the extinguishment of rights. So I think it's interesting if you look at native title and its 2 points of vulnerability, being the grant of inconsistent rights to settlers and the loss of traditional connection. That really is quite an accurate description of colonisation. That is what colonisation is. It is an alien sovereign coming in and giving land to its subjects and removing the original inhabitants. So it's kind of one of the perverse outcomes of native title, but it effectively grants legitimacy and legal certainty to those actions. So this issue of connection has been a principal barrier in Victoria because of that widespread sort of colonial violence and forced removal from country that I talked about. The seminal decision on connection is in fact a Victorian case. It was the Yorta Yorta High Court decision in 2003. And it gave us this infamous phrase, the tide of history, essentially used in the context that the tide of history had washed away traditional owner rights. This had a major impact, I think, on the development of the Settlement Act. And in many ways, the Settlement Act is a direct reaction to this outcome. In 2001, Dr. Wayne Atkinson, who was one of the principal claimants in the Yorta Yorta decision and now sits as a commissioner on the Europe Justice Commission, he said at that time, unless the barriers to land justice in the Yorta case are removed, the rhetoric of Mabo and the principles of law on which we pinned our hopes will remain elusive. So what followed Yorta was, a period of sort of prolonged advocacy. There was the establishment of the Victorian Traditional Owner Land Justice Group, and in 2005 they put out a statement calling for a comprehensive land settlement system in Victoria. By 2008, they'd got some traction, and the government put together this steering committee, which delivered its report, which laid the foundations for the Settlement Act. So both the report and the Settlement Act, they kind of confront the two fundamental barriers in the Native Title Act. The first being the extinguishment of rights when land is given to settlers, and the extinguishment of rights upon a loss of connection. So they attack these two problems. Just firstly dealing with the extinguishment of rights upon the grant of land to settlers. In Victoria, it's estimated that 2/3 of the state is private property and 1/3 is Crown land. So what that means immediately is that 2/3 of the state is off the table for native title purposes. The granting of that land as freehold has extinguished native title rights, leaving only 1/3 of Crown land available for claim. Now, under a native title claim, what usually will happen is the state will carry out a process called tenure analysis. So this is where the state looks at the Crown land within the claim area and examines it lot by lot, looking for historical acts of extinguishment. And they'll go back to first contact. So Crown land, although it may be Crown land today, at some point through the history of the colony, there may have been rights granted over it that extinguish native title. And if that happens, the native title is gone and that lot has to be removed from the claim. What the Settlement Act does in response is it recognises traditional rights over the entire Crown land estate. So in effect, it overlooks the effect of historical grants under the NTA, and there is a much greater amount of land over which traditional owners can have their rights recognised. On the loss of connection side, the Settlement Act doesn't focus on connection, and it's not a prerequisite to enter into an agreement with the state. Instead, the Settlement Act is trying to identify the right people for country, and the state has a lot of flexibility about who it may enter into a Settlement Act deal with. Firstly, in identifying the right people for country, if there's a native title determination, that will be the end of the matter. They are the recognised traditional owners. But quite commonly throughout the state, there is no native title determination, one way or the other. In which case, the state can enter into an agreement with any group capable of registering an ILUA, an Indigenous Land Use Agreement, which is a contract under the Native Title Act, which I'll discuss a bit more as we go on. Perhaps in the greatest expression of the flexibility within the Settlement Act is that the state can also enter into agreement with groups where they have had a determination that their native title is extinguished. So even where native title is extinguished, the AG can recognise the traditional owners through the publishing of a gazettal notice and can enter into agreement that way. So just having a look now at the content of the Settlement Act. So after overcoming or seemingly overcoming the structural barriers to Victorian traditional owners gaining recognition, the steering committee went on to design the content of an RSA. And what they were doing in building this content was responding to the consent determinations that were sort of around at the time, throughout the country. And the standard agreement that they came up with, or the framework from which these agreements fall, it contains two broad components. The first is a financial component, and the second is a recognition of rights. So the financial component, that is, essentially a bucket of money, but it can be broken up into a few pieces. The majority of the funding or compensation is provided to the traditional owner group entity, the TOG, which is the corporate representative of the traditional owner group. And those funds are untied and can be invested as the group chooses. A portion then is also placed in trust, and the returns on that trust investment are designed to cover the operating costs of the TOG in perpetuity. There's also an opportunity to receive surplus Crown land. So that is Crown land that is now surplus to the state's requirements, and the value of that is deducted from the financial component. So that's the funding side, or the financial side. On the recognition of rights, that can be sort of further broken down into three components. The first is the joint management of national parks. A handful of parks may be handed back to traditional owners as Aboriginal title. It will be managed by a majority traditional owner board, and their role is to develop a joint management plan, and there is funding set aside for the implementation of that plan. Beyond that, there's also rights around natural resource management and rights over land use activities. So that's rights when the ongoing development or use of Crown land is occurring. Traditional owners have some rights to respond and in some cases receive compensation. The natural resource management rights can sort of be broken down into another two components, which would be taken use rights and participation. So the taken use rights are rights to access land, largely for traditional purposes such as hunting, fishing, gathering, conducting ceremony, that type of thing. The participation rights are designed to allow traditional owners to engage and contribute to policy development around sustaining and maintaining country. So all of this is put into an agreement called the Recognition and Settlement Agreement that operates as a head agreement. It provides acknowledgement of the traditional owners and their rights, and also of certain historical wrongs that the group has suffered. And below that are a series of other agreements. There's a couple of sort of financial agreements, and then there's the rights agreements. So the funding and land agreement, the participation agreement, they transfer funds and land quite clearly, and set out the rules around the trust. The land management agreement establishes the board for joint management of parks and reserves. And the two big agreements sort of in terms of recognition of rights are the natural resource agreement and the land use activity agreement. So the natural resource agreement does what I indicated previously, allowing hunting rights and access rights, as well as participation in policy. And the land use agreement, the land use activity agreement, replaces the NT Future Acts regime and gives traditional owners certain rights when things are happening on the land. But that often might just be a right to comment. Sometimes it's a right to negotiate an agreement and receive some compensation. At the very high end, traditional owners do have a right of veto, and that largely applies to the sale of Crown land when the state is trying to sell off Crown land. Now, in addition to all of this, the parties are required to enter into an Indigenous land use agreement. As I said, this is a creature of the Native Title Act. It allows native title holders and the state and other parties to enter into agreements dealing with native title rights. And the way it's used here is to align the settlement deal with the native title regime. And the way it does that is that traditional owners agree not to pursue any further native title claims, and that they're not entitled to further native title compensation beyond what they've received in the RSA. We have some problems about the finality of some of those positions. Don't really have time to go into it today, but you can delve into the paper if you'd like to know more. Now, these documents are what are generally referred to as the templates. It's important to know that many of them come pre-written, essentially. Many of the rights contained within them are not really up for negotiations in an individual traditional owner negotiation. So moving on now to try and evaluate some of the outcomes under the Settlement Act. And it is important, I think, to acknowledge that there's certainly been some worthwhile achievements. It certainly has overcome the constraints of the Native Title Act as expressed in the Yorta Yorta decision, and groups that have achieved outcomes, are exercising rights over much more land than would ever be available to them in an NTA claim. But there are, I think, at least two ways the Settlement Act is not really delivering, and which will need to be addressed for a local framework, I think, to sort of work, at its best. So the two areas that we address as problematic is first efficiency, and that is it has not resulted in a more efficient system of claim resolution. That is, it's not getting outcomes any quicker than the Native Title Act. The second is inflexibility and predetermined outcomes. Because the framework is it's not subject to ongoing review, means that it can often be quite rigid in its application. And this can be frustrating for TOs who come to negotiations hoping to have an open discussion with the state, and often find that much of the deal is kind of already there, bound up in legislation and templates. So there is a perception that this system is sort of unresponsive to individual aspirations, and it also at times doesn't immediately keep pace with native title law developments, and also sort of some of the comprehensive agreements we're seeing now in other states, particularly in Western Australia. You may be aware of the Noongar and the Yamatji agreements, which have quite a high profile. And we go into that in some depth in the paper, but we don't really have time again today. So looking first at the issue of efficiency, the Native Title Act has long been criticised for the lengthy delays in resolving claims. Mabo itself took 10 years to resolve. It was, of course, facing the hurdle that it first had to actually invent native title. So 10 years is probably not too unreasonable. But the introduction of the NTA did not really reduce timeframes that much. Between 1994 and 2011, the National Native Title Tribunal sort of says, there's about a 6 to 7 year average in resolving claims. Those figures, I think, are an underestimation, because the way that the tribunal has framed it is they're counting the time from when the claim is filed with the court until the court disposes of it. And anyone who's been involved in a native title claim knows there's a lot of work that goes on prior to the claim being lodged. Years of traditional owners organising before you start research and so on. So, by contrast, the Settlement Act was intended to be much more efficient. It was going to be a straightforward process driven by goodwill negotiation between the parties. The process encouraged TOs to avoid filing proceedings in the federal court. The idea was to not have an adversarial approach, and instead, where the state and TOs were in disagreement, it would be resolved through discussion and mediation. The same was true for intra and inter-TO group disputes. So that's sort of internal disputes to the traditional owner group and disputes between groups. And those things could be over things like boundaries or internal group composition, the inclusion of ancestors, and so on. All of this was meant to be handled by sort of mediation. For that reason, I think it is a bit disappointing that we are now 10 years in, more than 10 years in, and we've only got 3 agreements reached under the Settlement Act. Of these 3 agreements, it's also worth noting that the first 2 were very well advanced native title claims. So the first agreement is with the Gunai Kurnai in 2010, but they had filed their native title claim in 1998. So there was a total of 12 years to resolve that, and it was a very well advanced native title claim by the time the Settlement Act sort of came in and resolved it. The same is true for the Dja-Dja-Wurrung. They had their RSA in 2013, also had lodged their claim first in 98, and a total of 15 years to resolve. So only the third agreement, the Taungurung RSA reached in 2018, didn't involve a native title claim. So this was the first negotiations to proceed without also filed in the federal court. And this was, in a sense, the pure scheme of the Act. This was the way the Act was meant to operate, without any involvement or oversight from the court. Nevertheless, there was 15 years of research behind the Taungurung claim. And once they got into negotiations, that was another 5 years of discussions with the state. So following the scheme of the Act, as I said, there was no involvement of the court or the tribunal. And once agreement was reached, the Taungurung registered the Ilua with the National Native Title Tribunal. The tribunal examined that document and agreed to register it, which would ensure alignment with the NTA. And this saw the re-emergence of an underlying TO dispute, and a new process was commenced under the Native Title Act, in which this dispute was prosecuted. And so what happened was some TOs sought judicial review of the tribunal decision to register, and the court examined the process of registration and found some flaws. And the result is now that 3 years after that agreement was first signed, it remains unregistered. So that's now, you're now looking like 18 years for the Taungurung, and this whole picture is not one of efficient resolution of claims. So if we're considering why the Settlement Act hasn't resulted in speedy resolutions, I don't think there's a single answer. These questions are always multifaceted. But I think one significant issue is that the Settlement Act really doesn't adequately address the prevalence of disputes created by post-colonial land reform. Wherever you see post-colonial land reform around the world, there are many disputes. It's one of the, when you're trying to deal with the consequences of colonisation, especially in relation to land, it's going to generate disputes. And I mean, this was known to the drafters of the Settlement Act framework. In the 2008 report, they referred to the fact that there's limited support and incentive for resolving these disputes, and that these disputes can be complex and seemingly intractable. So the steering committee response was to establish the Right People for Country project. And this was to be a transparent, respectful and non-adversarial process to identify the right people for country. Now, the approach taken by Right People for Country and other sort of culturally appropriate mediation services is very useful. Its aim is to avoid or minimise community trauma, and we see so much of that otherwise in Native Title Act processes. And secondly, it seeks to be Indigenous-led and consistent with empowering the community and self-determination. However, currently under the Settlement Act, mediation is the sole method it provides, and one of the problems is if disputes are truly intractable, that means they can't be mediated. That means you can't find a resolution through mediation. And if you continue to mediate them, you really just risk prolonging the dispute and the associated trauma. So in those circumstances, what you need is a release valve where the parties can get a fair hearing. And hopefully after a resolution is reached, there's an ability for the re-establishment of functional relationships and healing. But currently, under the Settlement Act, if the parties can't resolve a dispute by mediation, they have to fall back on Native Title Act processes. And that means they're thrown back into the very system the Settlement Act was set up to help them avoid. And it's adversarial, legalistic, culturally unsafe. And it's a system either designed by or for traditional owners. So that's what we say about the inefficiency of the Settlement Act. Moving on now to look at some of the inflexibility around the framework. So when the Settlement Act was set up in 2008, as I said, it was responding to the standard NTA outcomes at the time. What it sought to do was to standardise these outcomes so they could be applied universally across the state to all traditional owners, regardless of their likely treatment under the NTA. The state also has an implicit interest in achieving uniformity among traditional owner groups. Firstly, it needs to operate a cohesive land management system which means that it doesn't want different regimes, different sort of land management regimes in different parts of the state. It also has an interest in treating all traditional owner groups equally. That is, the state doesn't want to recognise different level of rights among traditional owner groups and doesn't want to discriminate amongst them. However, the result of all this is that you end up with this highly structured and frequently inflexible framework, because every time a TO group tries to negotiate something outside of the framework, that suddenly brings up statewide implications. Because to accommodate, sometimes even minor requests, the entire framework needs to be adjusted. So what this means is that when traditional owners approach negotiations, they're going to find that some things are negotiable and some things are not. And by the time a group, after getting through thresholds and sitting down with the state, they're going to find that many positions are already locked in, either by the principles set out in the steering committee report, the Settlement Act, the templates, and even by the positions negotiated by the traditional owner groups that have gone before them. Another problem with the framework, and I should acknowledge too that I think a lot of these issues are inherent to frameworks, is that they can become sort of fixed in time. And the framework obviously can't immediately reflect changes in native title law. Just to pull out an example, in 2013, we had the case of a keeper in the Commonwealth. This was quite a monumental case in that for the first time it recognised that native title rights could be commercial in nature. In this case, it was commercial fishing rights in the Torres Strait. So we're now 8 years on from that decision, and the Settlement Act framework still limits even the ability to negotiate around the recognition of traditional commercial rights. It's quite a complicated subject, and we do go into it in some depth in the paper. But yeah, even the recognition, so even the ability to negotiate for them to be included in a Settlement Act agreement is limited. Other sort of advances not caught, of course, would be the Timber Creek decision, which I'm sure most people would be aware of, is the valuation of native title compensation is not captured by the Settlement Act framework. It might be a little too early to be critical of the lack of inclusion of that, because traditional owners and state governments around the country are still grappling with that one. But there have been also, it should be acknowledged, some recognition of these issues by the state. There was amendments made in 2016 to the legislation, and more recently they established the First Principles Review. So this is a review consisting of traditional owners from around Victoria and senior level public servants. And it was established really to respond to the Timber Creek decision, but also a raft of other changes sought by traditional owner groups. In that sense, the state has been quite proactive in responding particularly to Timber Creek, but that review is ongoing and should report shortly. One thing that's notable about these attempts to sort of update or review the Settlement Act is that they are largely initiated by traditional owners. And there is no standing body that can sort of address issues as they arise. As issues arise, traditional owners need to go in and advocate for the change. And that means they have to expend a lot of effort just to sort of get to the negotiation table about these things. But mindful of time, we'll eventually seem to be going pretty well. Moving on now to talk about a local treaty framework and what that might look like. Obviously, we think the framework needs to address some of the weaknesses in the Settlement Act framework, and those weaknesses that we've identified is inefficiency in claim resolution and inflexible and predetermined outcomes. Now, inefficiency in claim resolution, that has a number of compounding effects, I think, on the whole process. One of the main problems is that it undermines confidence that that this is a process that will deliver meaningful outcomes, and traditional owners can lose faith in the project. Secondly, the slow rollout means that what you have is, sporadically every couple of years in some small pocket of Victoria, traditional owners have rights recognised. When you're a state government department and you're operating right across Victoria, it's difficult off the back of that to engender sort of comprehensive systems change and comprehensive cultural change. The slow rollout, I think, really sort of hinders that larger change we need to see from government. Our sort of policy solution on these are twofold. One, we think there needs to be less insistence on finality. So that is essentially an attempt to reduce some of the pressures on traditional owners by making them sign full and final agreements. Again, don't have time too much today to focus on that, but you can find it in the paper. The other policy solution, which I think I've foreshadowed a little bit, is more options for dispute resolution, and I'll go into that in a moment. On the other side around the inflexibility of the framework, we would suggest that predetermined outcomes are not going to be appropriate in a sovereign to sovereign negotiation. There's going to be a lot of commonality in what traditional owners are after, but nevertheless, we think there's going to need to be scope for individualised negotiations in the treaty process or at the local level. And so our policy solution around this would be, where there is commonality of interest, you can have traditional owners sort of collectively negotiate positions, and this could look something like a minimum package. But beyond that, the state is going to have to sort of abandon those standardised outcomes and meet with traditional owner groups on a sort of nation-to-nation level. And now we'll look at the wider options for dispute resolution before sort of looking at the concepts of the minimum package and individual treaty negotiations. So as I said previously, if mediation fails, currently the only way to resolve it is through the courts, and most commonly that's going to happen through NTA processes. Treaty, however, I think presents a unique opportunity, and it's an opportunity that hasn't been available to traditional owners at any time in Australian history, and that is to design a self-determined arbitration process fit for purpose for Victorian traditional owners. So this could operate a little bit like an NTA court process, although I would see it being much more informal, but it could be a forum where evidence and decisions are made about these sorts of issues. Unlike an NTA process, it wouldn't be concerned with the legal technicalities of the Native Title Act, and instead it would focus on the factual questions that are important to traditional owners. And it would be trying to resolve the things traditional owners need investigated and decisions made on in order to progress. So that could be things like the location of boundaries and questions as to the extent of country, issues of group composition and inclusion of ancestors, the potential inclusion or alleged exclusion of family groups. Naturally, this process would be designed by traditional owners, but just to paint a bit of a picture, it could be contained within the Treaty Authority. That would be a natural place for it within the sort of structure of the Treaty Act. It could be relatively informal, but would also have a disclosed and clear legal methodology to arrive at findings of facts. It could consist of a panel of elders, but it may also be useful to include sort of a prominent jurist, a former High Court or Federal Court judge, to ensure that sort of, the rules of evidence are complied with and what have you. That would also be useful, I think, because this process couldn't displace the NTA. So groups would still be able to commence proceedings in the Federal Court if they wanted to, but the tribunal could be designed in a way that seeks to align those processes. And the inclusion of a prominent judicial officer will, I think, allow the decisions to carry more weight if it gets sent up to superior courts. And yeah, so there are upsides to that. One of the other things I think is definitely necessary for this process to work is that the parties need to be equally resourced. So that is that all parties come into the dispute have access to historical, anthropological and legal advice. Now, it would be hoped that the self-determined design and the central role of elders could provide this body with a lot of cultural credibility. Unlike many current processes, it would also be public. There might be restrictions on evidence due to cultural reasons, but generally it would be much more public than what we currently do, and would also create a public record of these decisions. So now turning to the idea of producing a more flexible local treaty framework, when we think about what local treaties will contain, we see really two components. The first is a compensation and rights component, and the second is a political component. So the compensation and rights component would, is not dissimilar to what's currently available under the Settlement Act, but presumably is well in excess of what is attainable under that Act at the moment. The political component would be the recognition of the traditional owner group as a political community. And this is what would make it into a treaty, essentially, the ability or recognition of some sort of sovereignty and right to self-government. So our model suggests that these two components could be dealt with in distinct phases. The compensation and rights component could take the form of a minimum rights package. It could be collectively negotiated by all TO groups. Unlike the current framework, which was, firstly developed in 2008, and then the only involvement that traditional owners have with it is through their individual negotiations, where it's difficult to change, or lately through first principles review process. All traditional owner groups would be involved in the development of this process. It would also be immediately available upon passing agreed thresholds. So once groups sort of get recognised or jump whatever hurdles will be agreed by the Assembly and the state, this package is immediately available to them, and there's no sort of further negotiation. And the collective group of traditional owners that first negotiate the package would sort of stay on to oversee the implementation and to deal with issues as they emerge, and realign and renegotiate aspects as need be. The political component we see as being an individualised treaty negotiation. So, following the implementation of the minimum rights package, groups would have greater capacity and experience, but this would be the stage where the state is required to abandon standardised solutions, and they would need to start engaging with the traditional owner group on a sovereign-to-sovereign basis. We think there's a lot of advantages to the minimum rights package approach. We think traditional owners can probably achieve better outcomes through collective negotiation and leveraging off the state's requirement for a universal approach. It could help reduce the power imbalance and increase the capacity of traditional owner groups through the pooling of resources. The fact that it's immediately available should more efficiently move things forward. It won't be the case that groups have to spend years in negotiations once they sort of pass the threshold process. And the quick rollout would see it apply very quickly across most of Victoria, which would hopefully drive the systemic and cultural change that's needed within government. And some of the flexibility and rigidity we see in the current framework could be overcome by having this collective body of TOs overseeing implementation and issues as they emerge. The minimum rights package is also going to place groups in a strong position when it comes time for their individual treaty negotiations. They're going to have a significant financial and rights base. They'll have experience in complex interactions with government and in implementing a complex rights package. And we think this is going to provide a greater understanding of their own potential and aspirations. If a group is to go from, if you look at some of the unrecognised groups now, it may not even be incorporated. Their aspirations will probably be more limited now than they would be if they had a couple of years to implement a substantial package. We also think that once implemented across the state, you may find that more opportunities arise and become apparent. And really, we don't think at this stage there should be any framework limiting what traditional owners may be able to negotiate under this treaty component. If we were to speculate, though, the sorts of things that groups might want to negotiate, these will be localised sovereigns, and it's likely they're going to want to engage with the localised political authority. So in that way, they may seek powers that mirror what we put forward for the TRB at the state level. So that is, they may want to, take on local government functions or make laws and regulation in place of local governments, have reserved seats within local government, or act as a voice to local government. So look, that's the end of the paper. It's a big information dump, I know, but yeah, thank you very much for listening, and I'll just throw back to Paul before we are happy to take some questions.
Thanks, Dan. Just do that mute button. Thanks for a very comprehensive paper. There's a lot to take in there, absolutely. So, I think there's a lot to consider going forward. I was thinking to myself around the Settlement Act going forward, and how that might, if groups that are not have not negotiated a Settlement Act outcome at this stage, would they be looking to do the Settlement Act and the treaty negotiation at the same time, or is it a sort of a Settlement Act first and then a treaty negotiation afterwards? Just sort of thinking about that. What do you think about the progression to a treaty negotiation? Is it in parallel, or is it sort of moving from one to the next?
I sort of see it as a stepping stone. So I think the minimum rights package would take a couple of years to implement, and I think a group would probably benefit from that before launching into treaty negotiations. But I also don't think we should overprescribe what groups do. Like, groups can do what groups want to do. But yeah, I think if you look at, if you think of the minimum package as something in excess of what groups are currently receiving under the Settlement Act, when groups enter into those deals, there's a big leveraging up. There's a lot of staff to employ. There's a lot of communication with the mob that needs to happen, and that's a big job. And I think taking on and completing that successfully really sets a group up for more for the next stage, for going from that position as a rights holder and exercising your traditional rights to having yourself recognised as a political community. And I don't think there's any need to rush necessarily.
Yeah, I agree. It's about building that capacity to get a strong outcome and learning from those negotiations to go to that next phase. I think we've got one question
from me.
From you. You can read it there. I think I'll read it out.
This is actually. Sorry.
Is it? I think it's Ed, is it? But
it is Ed.
It's what about the arbitration system that is being used efficiently under the Aboriginal Heritage Act, and what lessons from the settlements in New Zealand, Toroa, that are each
sui generis.
Sui generis from John Altman, it says. So.
Oh, sorry, I've handed out. I've flicked out the link to people that was apparently under my address. So they've come into it.
Okay.
Thanks, John. In terms of the arbitration system, under the Heritage Act, I'm not sure which arbitration system you're referring to. I mean, the disputes I'm looking at are largely disputes between in traditional owner groups. And what we've seen with the Heritage Act is, that is a process whereby a decision is made, and they are quite frequently litigated. If you go through the sort of submissions around Heritage Act decisions, you can see that there's actually quite a high level of dispute within those decisions of the Heritage Act. I think there's lessons to be learned from them, but to an extent, they're not they're not as self-determined or as traditional owner led as I would like. I certainly the jump from the Heritage Act decision to the Supreme Court, I think, is unhelpful. And if we could get a traditional owner body determining those issues in public earlier, I think that would be a benefit. I'd hope that answered your question, John. I have to say I'm not terribly familiar with the New Zealand Aratoa dispute resolution process, apart from the claims process. But again, I'm sort of more looking at disputes between traditional owner groups.
There's another question there, Dan. You're probably reading it from Ed. It's view that regardless of the Native Title Act or the Settlement Act, land matters cannot be ignored in the context of any treaty negotiations. I love the no insistence on finality provisions because of the trauma colonisation will be ongoing. I think that's certainly consistent with the view around the treaty negotiations, is that as things change, then nothing should be off the table. But yeah, if you want to answer that directly.
Yeah, I mean, I agree. A treaty that doesn't deal with land is kind of hard to conceive of. I think land is so central to Aboriginal ways of being and politics and culture that I sort of couldn't imagine a treaty with it off the table. The problem is, though, that brings in the Native Title Act, and you bring in then Commonwealth legislation that you can't get around at the state level, and you have to try and navigate. So it does make it a bit tricky and unfortunate in some ways. The no insistence on finality, yeah, I think that's a real big one. I think the state has very little to lose by not insisting on finality. And I think it is a real issue for traditional owners. Having advised traditional owner groups, it's a big thing for them to sign off on an agreement that, no agreement is perfect. And certainly Settlement Act agreements are far from perfect. So, signing off on that and thinking that you may be signing away the rights of your grandchildren or have you is quite a difficult thing to do. And I think the state has little to lose and a lot to gain by considering shifting on those sort of provisions.
I think that's and Janet's view as well is that intergenerational expectations will change. We don't know what the future will hold. So I agree with that entirely.
Yeah, absolutely, and that's kind of the idea of the traditional owners, the collective of traditional owners, sort of constantly overseeing the implementation of the minimum rights package. What we've seen in the first principles review is, that is, sort of like a pilot program for that sort of approach in some ways, I suppose. And what we've seen is, that review, we're now 10 years after the legislation, and there's essentially like an accumulation of issues traditional owners have with the framework. And, they need to be addressed sort of on an ongoing basis. So I agree, but, it's difficult. And and state governments or all Western governments have a predisposition to want things finalised, to make sure they've got no more legal risk and whatever. But I think there does need to be a change in view, because treaty is negotiation between sovereigns, and that's an ongoing relationship. It's not a relationship that can ever be finalised.
Okay. So a large one there from Ed is a question that I'll read it out. The Resource Management Act in New Zealand is currently being reviewed. New Zealand has also committed to legislate the implementation of UNDRIP. It remains to be seen how these two factors will be brought together. I was chatting with this is from Ed. I was chatting from a senior colleague from Lincoln University, and his comment was that the RMA, I'm not sure what the RMA is, lacked procedures for properly engaging with Maori people on land use planning matters, and is hopeful that the review of the RMA and the introduction of UNDRIP legislation will yield better processes. So that becomes a reality. The Resource Management Act, thanks, Ed.
Yeah, no, absolutely, absolutely, Ed. I mean, this is a problem. I think, if I'm reading this correctly, that is sort of encountered in Victoria as well, where you see land reform happening in other areas, and Indigenous people's interests just get forgotten. Crown water frontages would be a recent example in Victoria, where one arm of government doesn't remember what doesn't remember their obligations to Aboriginal people. Hopefully, treaty puts in place comprehensive system where there are rights. And again, I think you need the big rollout. You kind of need the big bang to get government to sort of change across the board.
Another one there, Dan, from John. How do Indigenous people who are not traditional owners, maybe from interstate, historically get their rights and interests recognised?
That's a good question, John. And to be honest, I'm not sure it's one for me to answer, really. We are dealing with the Settlement Act. It arises out of native title rights. That means that we are dealing with the rights of traditional owners. I think this is a question for traditional owners and non-traditional owner Aboriginal people to resolve. And it's a tricky one, and yeah, I won't put in my 2 cents.
The only thing that comes to mind for me is around the statewide treaty that's been as part of the current discussions. Is the statewide treaty, which will obviously have statewide implications, and there's the localised treaty. So those traditional owners who are in Victoria, but traditional owners from interstate, they will be, impacted by that statewide treaty, and what rights that brings through that framework and through that negotiation as well.
Yeah, I think that's right. I mean, I think local treaties are very much going to be, or a big component of it will be about land, and the rights to land with traditional owners, and that more sort of complex relationship could be dealt with at the statewide level.
Yeah. Okay. One more questions coming through. We are just a few minutes over, so once again, thanks Dan for that comprehensive paper and presentation. Quick one just come in. What about sea and water rights as well as land? I think that would be.
Yeah, a good question. I mean, so the Settlement Act at the moment is really insufficient on sea and water rights. So when I talk about the minimum package being in excess of what's currently available, this is sort of exactly what I mean. Treaty in this sense is going to open up these doorways into things that have kind of been blocked for a long time. And I think water rights is right at the top of the list of things that traditional owners will be trying to achieve through local treaty framework.
Absolutely right. And water rights is quite a huge issue at the moment, whether it be the Murray-Darling Basin or otherwise. It's certainly something that traditional owners are taking a huge interest in at the moment. So definitely be part of that going forward. Okay, lots of thanks coming in, Dan. So yeah, thank you again. And just to everyone out there, the presentation has been recorded. It will go up eventually on our Facebook page, and the paper is on our website, and the PowerPoint will be emailed out to participants to be able to capture and review that at your own time. So thanks again, Dan. Thanks everyone for attending today and your questions. It's been a really interesting discussion, and we'll see you at the next webinar. Have a great day.
So, thanks, Paul.